Welcome, everyone, to this Transatlantic Currents webinar on policing in America. My name is Maria Linden, and I'm a research fellow here at the Center on U.S. Politics and Power at the Finnish Institute of International Affairs. I will shortly hand the virtual mic to our non-resident fellow, Leo Michel. But before I do so, I would like to thank the ERCO Foundation for their pivotal role in the founding of our center and for their support for our current activities, such as this webinar. And as you listen to the webinar, please feel free to type in questions and comments using the chat function. I'm going to read them out loud later on and give our guest speaker an opportunity to answer some of them. And now it's time to introduce our non-resident fellow, Leo Michel, who is also a non-resident fellow at the Atlantic Council. Leo has had a decades-long career in U.S. government, and he has been, amongst other things, a Government Distinguished Research Fellow at the Institute for National Strategic Studies, a Director for NATO Policy and Director for Non-Nuclear Arms Control at the OSD and Pentagon, and he's got degrees from Johns Hopkins and Princeton University. Leo, the floor is yours.
Thanks very much, Maria. Hello from Washington. And welcome to Professor Joanna Schwartz. Professor Schwartz is a professor of law at the University of California at Los Angeles, known as UCLA, of course, and she's the author of the recently published and highly acclaimed book, Shielded: How the Police Became Untouchable. I want to take 2 minutes to set the stage for our discussion today. In 1991, in Los Angeles, 4 white police were videotaped viciously beating Rodney King, a black man, whom they had stopped for driving while intoxicated. Millions of Americans across the nation saw that video on the evening news, and it was an unprecedented event. 1 year later, the police involved were acquitted by a jury trial of assault with a deadly weapon and use of excessive force. Los Angeles erupted with riots that killed over 50 persons, injured hundreds more, and destroyed many neighborhoods. In May 2020, George Floyd, a black man, was arrested for a minor nonviolent offense in Minneapolis. Mr. Floyd was handcuffed, pinned on his chest in the street as a white policeman rested his knee on Mr. Floyd's neck for about 10 minutes, ultimately suffocating him. The video and audio recording of his suffering and death made by a bystander on her mobile phone went viral. It sparked massive demonstrations across the US and overseas. There were, as you know, even demonstrations in Helsinki. In that case, the policeman was convicted of murder and sentenced over 20 years in prison. Yet despite the protests and calls for reform after George Floyd's murder, incidents of police misconduct and violence have continued in this country with disturbing frequency. In January of this year, for example, Memphis police stopped a car driven by Tyree Nichols, apparently for a minor traffic violation. He did not resist, but he was beaten so severely that he was hospitalized and died 3 days later. 5 of the officers, who happened to be black, as was Nichols, were arrested and charged with murder. Videos of the episode, taken from police body cameras and a nearby security camera, were released to the public. And even today, the Washington Post reports the following, and I'll quote from today's Washington Post. A grand jury in Akron, Ohio, on Monday declined to indict 8 police officers in the death of Jayland Walker, a 25-year-old black man. In total, the 8 officers fired 94 times during the shooting, prosecutors said. Nearly 4 dozen bullets hit Walker. The grand jury concluded that the officers were legally justified in their use of force, meaning they will not face any state criminal charges. And Ohio's Attorney General, the principal prosecutor in the state of Ohio, said that Mr. Walker had fired at least 1 shot at the police from his car. But Mr. Walker was unarmed when the police pursued him on foot and fatally shot him. So that's a little bit of the background of today's discussion. And let me begin, Professor, by asking you, how common are reports of serious police abuse, physical assault, and even killings Is there reliable data? And what trends have you observed? And have racial minorities, in fact, as it's often charged, been disproportionately affected by such abuse?
Well, let me begin by thanking you for this conversation and to the participants for being here. I'm delighted to be able to speak with you this morning. There is not good, reliable data, unfortunately, in the United States about how often police kill people. The best available data is collected by the Washington Post and the Guardian newspapers. And when the federal government saw that it was these private newspaper companies that were doing a better job than they were of trying to collect this data, they tried to collect it on their own, and after a few years said, you know, we really can't do this, and have left it to these journalists to gather data about fatal shootings by the police. And there's even less reliable data about how often police are assaulted or suffer some other kind of force that does not result in their death. So it's very hard to comment on trends, although different jurisdictions have done their own studies. And there is an indication that that killings have gone down from several decades ago, but still more than 1,000 people are killed every year by the police. And 2022 was since 2015, when the Guardian and Washington Post began collecting their data, 2022 had the highest number of police killings for that period of time. You asked whether it is true, as it seems, that police disproportionately use force and kill people of color in our country. And the data that we do have suggests that that is absolutely the case. Although there is not this national reliable data, there have been studies of different jurisdictions. And time and again, it is found that police disproportionately arrest, use force, and kill Black people, Latino people, and Indigenous people in our country.
Let's turn now to the heart of your work, where you describe various ways that U.S. laws, judicial rulings and interpretations of those laws, and other practices and biases have shielded, and that's the term that you use, shielded law enforcement agencies and individual police officers from criminal and/or civil sanctions, even when they've clearly violated a person's rights under the U.S. Constitution. So I wonder if you could generally explain what the Fourth Amendment to the Constitution says, and how does that relate to protections of citizens against police misconduct?
Sure. So the Constitution itself is one of those shields that I describe in the book. And the Fourth Amendment protects against unreasonable searches and seizures. That's the language in the Fourth Amendment to the U.S. Constitution. If you hear that language, certainly if I listen to that phrase, unreasonable searches and seizures, I think about it in terms of the person being searched and seized. If I am walking down the street and have done nothing wrong, and all of a sudden I'm arrested, or if a police officer uses a baton or a gun against me when I have done nothing wrong, that would seem to be unreasonable. But the way in which the Supreme Court has interpreted the Fourth Amendment, and it's the Supreme Court that really is the main and final arbiter of what the Fourth Amendment means. The court has interpreted the Fourth Amendment's unreasonableness phrasing to be considered in light of the officer's decision about whether to use force, whether it was reasonable for them to use force under the circumstances that they have faced. And the Supreme Court has said that when considering whether to use force, for example, and whether force violates the Fourth Amendment, lower courts are to consider the totality of the circumstances, everything that the officer is facing and considers at the moment that the decision to use force is made, not with, the Supreme Court says, 2020 hindsight. So this interpretation ends up meaning that a person who has done nothing wrong can still be assaulted or arrested or killed, even so long as the officer reasonably believes that they are a threat. And it's relevant to the introduction that you gave in the description of the case out of Akron, Ohio, where a man was shot dozens and dozens of times, although he was unarmed. He had apparently shot at police while he was in his car, but left his gun in his car and then began running away. At that time, running away, he would not presumably have been a threat because he didn't actually have a gun in his possession. And in fact, the Supreme Court has said it violates the Fourth Amendment to shoot someone simply because they are running away if they are not a threat. But in the officer's view, they thought that he still had a gun. They said in their testimony that he was reaching into his waistband as he was running away. And from the perspective of the officers, that would have been sufficient justification under the Fourth Amendment standards to shoot.
So let me dig into that a little bit here, because an important section of your book relates to something called qualified immunity. And let me just put this in, as I understood from your book, kind of in the historical perspective. There's a federal law known as the Ku Klux Klan Act of 1871 that was passed in the wake of the Civil War. And you explain in the book that its original purpose was to protect Blacks in the South who were being tortured and killed by members of the Klan and other white supremacist groups, while state and local authorities either stood by or sometimes even participated in those atrocities. So could you, and the intention, as I understand it, basically was to give a means then for people to file suit and get some measure of justice through the federal courts when the state authorities had simply ignored those constitutional rights. Could you explain how that law, which it's 150 years old now, was intended perhaps to deter police abuses and provide compensation for victims, and how interpretations of that law, specifically, as I mentioned, and you explained this in great detail, this doctrine of qualified immunity, have served as one of the shields, not the only one, but one of the shields for police misconduct. It's a big ask, but I'm sure.
No. It's a big question, and that's why I had to write a book about it, because these are big questions and also really important questions to ask and understand. So yes, as you say, the Congress in 1871 enacted this statute, the Ku Klux Klan Act, which is also referred to today as Section 1983, and that is for where it sits in the United States Code. It's 42 U.S.C. 1983, 1983. But this statute, after it was passed in 1871, essentially immediately went into disuse because of a variety of decisions made by the Supreme Court that essentially limited its power so greatly that people very, very rarely tried even to use Section 1983 as a tool to sue. And the few times that they did, they were unsuccessful. But if you fast forward 90 years to 1961, this is in the beginnings of the civil rights movement, as there was a lot of attention focused on, again, police misconduct and use of force around the country. The Supreme Court came to recognize again that it needed, or the federal government needed, to provide some means of vindicating people's rights because it wasn't happening in the state courts. And so in a decision in 1961 called Monroe versus Pape that I describe in the book, the Supreme Court came to recognize and affirm that people whose rights had been violated by government officials, in that case by police officers, could use Section 1983 to bring a lawsuit seeking money damages or other kinds of forward-looking relief, referred to as injunctive relief, against those police officers and departments. And soon after Section 1983 was affirmed or vindicated in this way in 1961, there were many lawsuits brought against the police and other government officials. Not surprisingly, it was really the only way to sue, because state laws really provided no kind of remedy. And there was a lot of concern that there were too many cases being filed, that plaintiffs in these cases and their lawyers were abusing the power to bring these cases, bringing frivolous cases, and wasting people's time with these cases. And it was 6 years after Monroe versus Pape that the Supreme Court created this doctrine called qualified immunity. And it really was created. There's nothing in the statute, nothing in the Constitution that allows for this protection of qualified immunity. But when the Supreme Court first announced it, they described it as a good faith defense. This was a case in which an officer had arrested a group of Black and white ministers who had traveled to the South as part of the civil rights movement, and they were arrested for being in a segregated coffee shop. The statute under which these ministers were arrested was later found to be unconstitutional. But what the Supreme Court said was this officer had a good faith belief that he was enforcing the law, and so was entitled to this qualified immunity. But the protections of qualified immunity have gotten increasingly stronger in response to repeated claims that I contend are overblown, if not false, about the dangers of making it too easy to sue. And so in 1982, the Supreme Court changed qualified immunity, said it didn't have to do with officers' good faith. Instead, the question was whether officers had violated clearly established law, which was an objective standard. The court said they didn't want to turn qualified immunity's protections on the officer's subjective intent, because you might not know about that intent until you get to a jury, till you get to trial. And the goal of qualified immunity was to cut off these, quote, insubstantial cases early. So they said, all right, qualified immunity is about whether officers have violated clearly established law, but didn't define what that means. And over the next set of decades, we're basically 4 decades out from that decision, and the Supreme Court has created a standard that is virtually impossible to meet. The court has said there has to be a prior court decision from the United States Supreme Court or a court of appeals, which is the next level down, ruling unconstitutional virtually identical conduct. It's not enough to say that an officer used force against a person who had surrendered and wasn't resisting. That is a well-known interpretation of the Fourth Amendment. It is unreasonable to use force against a person who has surrendered and is not resisting. But to overcome qualified immunity, you have to show that an officer used a prior case in which it was held unconstitutional, that an officer used a similar type of force under similar circumstances. And that is a very difficult standard to meet. And I should say also, before I stop talking and let you ask another question, that this is over and above the protections of the Fourth Amendment. So qualified immunity only does its work once a person has proven that their Fourth Amendment rights were violated, which, as we've discussed is already a high standard. It has to, you have to show that an officer in the moment, given all of the circumstances, was acting unreasonably. Then, in addition to proving that, the plaintiff needs to find a prior case in which it was held similar conduct, very similar conduct, was held to be unconstitutional.
So one of the things that I found most impressive about your work is that you include each description that you include of a general problem. You relate this to one or two, or sometimes more, real life cases of persons, and I should say of different races and backgrounds, who have suffered arguably from police abuse. And you've shown some really perverse applications of this doctrine of qualified immunity. And I wonder if you might briefly discuss one, or if we have time, two of them. One I recall happened in Hawaii, involving the use of a taser, the police use of a taser against someone who was certainly not threatening them, and other contrast between two people who were shot by police with their hands raised, unarmed, but they were like in a different physical position. And because one could not claim that he was in the same, his victim was in the same physical position with the hands up as someone else, it was basically thrown out of court.
Sure, I'm happy to speak about them both. The second one I'll talk about first, and it actually involved it was not a shooting, but involved the use of a police dog. Although everything else that you've said is absolutely correct. There is a case brought by a man named Alexander Baxter, who had burgled a home in Nashville, Tennessee. And he was, the police came to the scene. He was sitting in the basement of another building close by, saw the police, and sat down. He was sitting down and surrendered, putting his hands in the air. After having done that, the police nevertheless released their police dog on Alexander Baxter, and the dog took a big bite out of his underarm, and he suffered pretty significant injuries. He ended up bringing a lawsuit, and the case was against the officers was dismissed on qualified immunity grounds. As I'd mentioned a moment ago, it is well established and understood that police cannot use force against a person who has surrendered and is not posing a threat. And that is exactly what the officers in this case did. Alexander Baxter was sitting down with his hands in the air when the police dog was released against him. But the court dismissed the case anyway, because he couldn't find a prior court case with sufficiently similar facts in the court's mind to clearly establish the law. Now, this is even though there was a prior case decided 5 years earlier, I believe, by that same court that ruled that it was unconstitutional for the police to release a police dog on a person who had surrendered by lying down. But in the court's view, there were enough factual dissimilarities between the two cases, even though they both involved a police dog, even though they both involved a person who had surrendered, there were enough factual distinctions because Alexander Baxter was sitting down with his hands in the air and the other person was lying down in surrender to mean that the law was not clearly established. And those officers were granted qualified immunity. The other case you mentioned coming out of Hawaii involving a woman named Giselle Matos was a case in which Giselle's daughter called the police to say that her mother and father were fighting and things were being thrown around. And the officers came to the scene and saw Giselle's husband sitting outside. clearly intoxicated. The officers asked for him to get Giselle so they could see her and see if everything was all right. He went inside the house. One of the officers followed him inside, and they started arguing. Giselle came out and said, "Please, let's take this conversation outside. My children are in this home. They are asleep. I don't want to disturb them." And one of the officers went to grab Giselle's husband. She was in between her husband and the officer, and she put her hands up so that the officer's body wouldn't crush against her breasts. He stepped back, said, "Are you touching an officer?" and then tased her. So the officer tased the potential domestic violence victim that they were there to protect. She brought a lawsuit. The Court of Appeals said this was clearly unconstitutional. Anyone should know that using force under this circumstance was unconstitutional. And the fact that they didn't warn her before tasing her sent this use of force, in the court's words, beyond the pale. But these officers were granted qualified immunity, even though the conduct was clearly unconstitutional in the court's view, because there had not been a prior case involving the use of a taser in similar circumstances. So in that case, it was the fact that it was a slightly different weapon that was being used that entitled the officers to qualified immunity. I should say there are so many other cases, and I thank you for the kind words about the stories in the book and the use of the stories. I think they're very important parts of the book to me, both because I think it's extremely important to really see how these doctrines work in practice in cases that the U.S. Public hasn't heard of, far less anyone anywhere else. But it's important to reveal how these doctrines and protections work. And it's also important to me to be able to share these stories that haven't been heard for these families and these victims. But there are so many other stories that I could have included. I could tell dozens of stories about the injustices of qualified immunity and the Fourth Amendment, and had to select between so many heart-wrenching stories to tell in these cases. There are so many more stories than the ones I tell.
So one would have hoped that the constitutional also the right that was recognized to have a suit against law enforcement officers who commit abuse or sometimes even murder, that would have served as a deterrent to future actions, and also get some sort of damages, some sort of compensation. Though, of course, obviously you can't compensate for the loss of a life. And here, I want to do two things. I want to point out to the audience, and I believe you include this in your book, that George Floyd's family received a $27 million settlement from the city of Minneapolis. And some people might say, oh, well, see, that argues that the system really works and so forth. But I think what is so good about your book is that you explain, actually, that's pretty rare. And there are so many other obstacles, shields in the system that work to discourage people from even being able to file a lawsuit, a civil rights lawsuit, or to have one prosecuted successfully. So in addition to qualified immunity and people on the webinar, we'll just have to read your book, and we'll post a link to your page that has a lot of your shorter articles as well. Could you sketch out some of the other type of shields that happen for police misconduct? I mean, there's some examples that are really dramatic of misconduct by Chicago police, or a Chicago police officer, I should say, who's protected by a code of silence in his department, or even in the city of Vallejo, California, where over one period of time, police killings accounted like 30% of shootings or 30% of murders in the city of Vallejo. It's just, it's mind-boggling, as we would say.
It is mind-boggling, and there are 13 chapters in the book, and 12 of them are focused on shields, including qualified immunity and the Fourth Amendment, but many others. And as you describe, it can be difficult. The way in which the Supreme Court has interpreted the law makes it difficult to find a lawyer to begin a lawsuit with sufficient facts to justify the entitlement to get to the discovery stage of litigation, proving a constitutional violation, overcoming qualified immunity. It is as difficult, I believe, to prove that a local government is responsible for the misconduct of its officers than it is to overcome qualified immunity. And that chapter is dedicated to Vallejo, California, which is, as you've described, a truly horrific police department, completely dysfunctional, violent, and essentially there's a gang mentality among the officers who have bent their badges in commemoration of police shootings, and done truly shocking things, and yet the city has not been held responsible for misconduct by their officers, even though the police chief during this most violent period of time never disciplined or fired any of the officers involved in these cases. And then I also dedicate chapters to thinking about the impact of these of settlements and judgments when they are successful. And part of what I talk about is the ways in which state and local governments' policies and laws have insulated officers and departments both from the consequences of these cases. Officers very rarely contribute any money at all in these settlements and judgments, and police departments also don't face financial consequences in these cases. All too often, the money to satisfy settlements and judgments doesn't take away anything from the police department, but from other parts of the city's budget, which tragically are often earmarked to go to those who have the least political power. In fact, those who are probably disproportionately mistreated by the police. And that is where the example from Chicago comes in. And even when there is money paid, as I show in the penultimate chapter of the book, departments very rarely gather and analyze information from these suits with an eye toward preventing something similar from happening in the future. So there are many, many shields that I describe, and the upside, I suppose, is there's so many so many barriers erected at so many stages of litigation process by so many government actors that it means there's a lot of opportunity to improve and a lot of ways in which the system could be made better. And in the final chapter of the book, I talk about some of those ways, that from the federal government down to just individuals reading the book, ways in which they could improve the system.
So let me, and this will be my final question, and then we'll see if there are questions sent in on the chat. You do conclude in that final chapter with several suggestions for reform measures. I would point out at both the federal and state levels, both to deter the police abuses and to fairly compensate victims. You highlight the importance of abandoning or severely limiting the use of that qualified immunity doctrine. But even in the wake of George Floyd's murder, the House, which was at the time controlled by the Democrats, passed a law to address some of those abuses, but the Senate could not reach a deal on police reform. So do you see any signs of progress on these issues, either inside or outside of Washington? And what happens if Americans really can't act on this? It's a little bit outside maybe your immediate study, but I mean your personal views. What happens when there's a failure to act? What effects are we looking at on the fabric of American society and, frankly, the rule of law?
Well, I do think that there are important changes and efforts that are being made at the state and local levels. Unfortunately, at this moment in time, I have very little faith in the federal government's ability to address these issues, even as I think they absolutely should. Even though I think that a federal response, a response that addressed the entire country and law enforcement within the entire country would be the absolute best result. I don't see it happening in our current political climate. I think, unfortunately, and unfortunate is too tame a word. It's tragic, and to my mind, it's really horrifying that there has become this rhetoric that suggests that people who are interested in police accountability hate the police, and people who love the police hate police accountability. And the discussion around qualified immunity doctrine has really taken on that hue, where people who are trying to reform this doctrine that truly makes no sense, in my view, are accused of wanting to or further the demise of the strength of law enforcement, and hurt recruitment and hurt officers' abilities to do their jobs. I think that there has been more room outside of Washington to try to negotiate some common sense basic reforms. And although qualified immunity has had some success in some states, but there are other changes as well. There have been changes to gather more information, to try to get better data about what police are doing. There have been policies put in place to limit police authority and power to engage in low-level traffic stops, for example, to have unarmed mental health professionals responding to people in mental health crisis. And these kinds of changes are at sort of the front end to reduce the number of contacts that officers have with people. I think that is an extremely promising approach. When it's happening at the state and local level, it's happening piecemeal. So there are some places, I live in California, and that is a state where there is a lot of effort and energy to try to address these issues. In a state like Texas or Florida, there is very little chance of these kinds of bills being passed. But my optimistic side says that if bills are passed in California and they end up demonstrably making things better, then perhaps those successes can be exported to other states. So I do have some hope, but I think that the picture is largely depressing. And if you ask about the rule of law, I think there's a lot of very powerful research that talks about the kind of legal estrangement. Monica Bell, professor at Yale, talks about legal estrangement when people have their rights violated or see other people who have their rights violated, and there is no consequence. And I think that we are facing a period of that kind of legal estrangement in our country as it relates to policing. And that is part of what really needs to be combated by these state and local initiatives.
Thank you. Maria, let me turn it back to you in Helsinki. Thank you so much, Professor.
Thank you, Leo, and thank you so much, Joanna, for all these enlightening insights so far. We have one question from the audience, and please, the rest of you in the audience, if you have any questions at all, please type them in. So the first question is that since the doctrine of qualified immunity is a judicial interpretation, could it be reversed by the Supreme Court? Or is the system so entrenched against such a challenge that a federal law reform would be the only way?
Terrific question. It is a doctrine that is created by the Supreme Court, and the court absolutely could reconsider qualified immunity. In fact, the court has, I would say, sort of flirted with the idea that it would reconsider qualified immunity. Clarence Thomas, who has been in the news for other reasons recently, was in the late teens, I think it was 2017 or 2018, issued a concurrence in a decision where he said that he would recommend that the Supreme Court reconsider qualified immunity. And this got a lot of people's attention because Clarence Thomas tends not to be very sympathetic to civil rights plaintiffs. But his concern was none of the concerns that I've been raising about deterrence and justice and accountability, but instead his concern was that qualified immunity doctrine was not part of the original fabric of the Ku Klux Klan Act, the Civil Rights Act of 1871. It was sort of an originalist type of argument. And he said that qualified immunity doctrine had been was sort of a product of the justices' public policy interests as opposed to anything based in the statute, and so that it should be reconsidered, potentially rolled back. And following that suggestion by Justice Thomas, there was a lot of attention on the Supreme Court, efforts to have the Supreme Court do just as Justice Thomas had suggested and reconsider qualified immunity. And in fact, there were multiple petitions, I think over a dozen, that were being considered by the Supreme Court at the time that George Floyd was murdered. And many of those petitions to reconsider qualified immunity had been what's referred to as recalendared multiple times, meaning the Supreme Court had conferences deciding whether to decide to hear these cases and then had put it off and put them off and put them off. And many of us who think about these things thought that there really was a possibility that the Supreme Court would take one or more of those cases and reconsider qualified immunity. Ultimately, they did not grant certiorari in any of those cases. The common wisdom was perhaps because the court was going to have Congress, they could see that there was a lot of action with Congress to possibly pass a bill that would do away with qualified immunity or adjust it, which, as we've just Leo explained, never passed the Senate. The Supreme Court did in November of 2020 issue a very short decision in a case called Taylor versus Riojas that I talk about a bit in the book, that said that in extreme situations, a plaintiff does not need to find a prior court case with virtually identical facts. But so there is this sort of hint that maybe the court is stepping back from its most robust descriptions of the doctrine, but it's only a hint at this time. And although the court could take a much more vigorous stance and could do away with qualified immunity altogether, they haven't suggested that they're willing to do so. If I can say one more thing, we've been talking about the Supreme Court and Congress's ability to do away with qualified immunity. There's actually an interesting thing happening in some states. Now, states do not have the power to change federal law. They don't have the power to do away with qualified immunity in these Section 1983 cases. But some states have created state law rights to sue for violations of the state's constitution, and have said that qualified immunity is not a defense in those cases. So they're essentially creating a state parallel cause of action to Section 1983. And it's an irony that states that originally Section 1983, the Ku Klux Klan Act, was enacted to create this federal law where states were not stepping in. It's now states that are creating their own right to sue to respond to federal courts and the federal laws' inability or unwillingness to vindicate these rights.
Thank you. I actually had a question myself. There are some more from the audience, and I will return to them shortly, but I just wanted to abuse my powers here a little bit and ask a question myself. I was interested in the politics and kind of the possibly underlying racism in all this, and I was wondering if you'd be willing to discuss that aspect a little bit. You did mention that in the recent years, this has become more polarized, and there's this harmful rhetoric about where people have to be either police lovers or police haters and all this. But even decades back, when this qualified immunity interpretation of the law originally happened, it's so absurd. It strikes when you hear about it and you hear these examples, it blows your mind, really, that there could be such a decision. So one wonders, was it political all along? Was it racist from the start? What were these underlying larger thematics that may have influenced? What was the composition of the Supreme Court at the time? Was it a liberal or a conservative Supreme Court that originally came to this interpretation of the law? So I was wondering if you could kind of explain that a little bit.
Yeah, it's interesting. The qualified immunity was first announced as this good faith defense in 1967. This was still the court that was helmed by Justice Earl Warren, who was the Warren Court, as it's referred to, was the most liberal Supreme Court that we have had in this country, and it was the court that really recognized many important constitutional protections and bolstered many constitutional protections. But toward these later years of the court, there are also decisions that were stepping back from those larger protections, and often sort of in the interest of creating some sort of balance, a balance between the needs to vindicate people's rights and too much disruption of the police power. And you can see it in the case creating qualified immunity. It's also in a case called Terry versus Ohio that I speak about in the Fourth Amendment chapter, that allowed police essentially to stop and frisk people who are walking down the street without full Fourth Amendment protections. I think that it's impossible not to view those decisions from the perspective of the late 60s and what was happening in the late 1960s in our country. There was a lot of protest, a lot of racial struggle. This is the the heat of the civil rights movement, and I think it's impossible to read these decisions or really anything else that happens in the United States apart from race. It is a defining characteristic of our politics and our society, and I can't get into the heads of the justices or the politicians. Certainly, there was nothing explicitly said as regards to race in those decisions, but I think it is impossible not to see race as playing out in all of these cases. I mean, even as I said, the case that was the first announcement of the protections of qualified immunity brought by a group of Black and white ministers who had sat in a segregated coffee shop. I mean, race is very much apparent even in that initial decision. So it's impossible not to think of race as part of a deep part of this history that we have. Following the murder of George Floyd, part of what was noted was that there was more racial diversity in the protests than there had ever been before. And I think that it was a moment where white Americans saw themselves implicated, saw the stakes of these issues. But it's also true that that moment and that intensity of that moment has passed. And it's you don't want to have to wait for another horrifying incident to get public attention once again focused on these issues. This is part of the reason, as Leo mentioned, I tell the stories of a wide variety of people in this book. People who are white, people who are Black, Indigenous, Latino, rich, poor. I tell the story of a white executive who was making $250,000 a year, who was killed very much in the same way that George Floyd was, with a knee to his back and neck. And I think it's important for people who are considering these issues to understand it is not just an issue involving Black Americans. Although even if it were, it should be an issue that motivates us all to change. But I think I am banking on the idea that it is important and powerful to have readers see themselves in these stories and to recognize that they are at risk too. We as a society, we are all at risk until we have a system that functions in a just manner.
That's a really, really good point. We have one more question from the audience, and I think then we're gonna have to start wrapping up. So this question begins with a thank you for drawing attention to the issue. In case you have followed the Stop Cop City protests in Atlanta, Georgia, the probable police murder of Indigenous activist Manuel Terán, and RICO-based charges of domestic terrorism against peaceful activists, I'd like to hear your thoughts on it, and what should we as an international audience pay attention to in this particular case? Reads the question.
Well, I think it is. I'll speak more generally about the international audience and whether it is focused on Stop Cop City in Atlanta or any of these other issues. I think it is encouraging to me to have been invited to talk with this group. And I really, again, appreciate the invitation. I think the U.S. Has, often been accused rightfully of really only caring about itself and having this very sort of insular focus. But I also think that international attention matters. And I think that international criticism of the way in which the U.S. government handles policing matters. I think it mattered to the U.S. government when there were the international protests following the murder of George Floyd. I think that is part of the reason that there was action that was considered and explored. I think that historically, over time, the U.S. has shown that it is responsive to international criticism. And in fact, the Supreme Court's decision back in 1954 to desegregate its schools was is in part viewed as a response to international criticism of those practices. So I think that continuing to express your interest and concern is of value. I'm hopeful that international human rights organizations continue to explore and investigate what's happening in the United States, and especially when U.S. law is so deficient in addressing these issues. I think that having international attention, international investigations is very valuable. I was just reading yesterday about an international investigation of the Portland Police Department in Oregon, and these kinds of investigations and attention, I think, are one of many ways to try to push for change. I don't think there's any on-off switch here. I don't think there's a magical ticket that will get us to the system that we deserve and need, but any of these advances and attention can move us closer.
Thank you very much. Well, we still have 2 minutes left, but I doubt, since we don't have any more questions from the audience, I doubt that there's really time to address another. These are all such large issues that there probably isn't much that can be covered in 2 minutes. So somebody's still typing, but I'm presuming it's probably to say thank you. So, well, there's actually several people typing now. So let's see. Yes, they are thanking for your answers, and thanking the organizers for this webinar, saying it's been fascinating.
Thank you so much for coming.
Thank you. Thank you to the audience.
I hope you'll look at the book. It has much more and more in depth than we could possibly discuss within the hour.
Yes, I put the link in the chat on Joanna's profile on the UCLA website, so you can find the information about this book and her other publications via that.
I've included a link to my website as well that offers some additional information about the book and other work.
Excellent. Thank you very much. And thank you so much, Joanna. This has been really insightful and, as I said, mind-boggling. It's it's very, very sort of hard to understand how things can continue to be so fraught, and how it can be politically so seemingly impossible to fix things that should be in everybody's interest and should just be non-controversial, how they can become so incredibly controversial. But yeah,
I agree. I agree.
Once again, I feel blessed to be a Finn and not to drive around streets where I have to wonder if I'm going to get shot just by just for driving a car. I had my driver's license when I was living in the US. I had a Massachusetts license, and part of the driving license training was to learn how to behave if a police stops you so that you won't get shot while you're being stopped. And it was a shocking chapter to read in a driver's manual, because in Finland, when I originally got my license in Finland, that is not something we feel the need to teach. It's kind of an assumption here.
Yes.
But,
Well, welcome to America.
Yeah. But anyway, thank you so much. Thank you, audience. And thank you, Joanna. Thank you, Leo, for once again finding a fascinating speaker for us and for conducting such an interesting interview with her. So I declare this webinar now officially over, and hope to see many of you in our following webinars.
Thanks
Thank you,
very
everyone.
much.
Thanks very much, Maria. Bye-bye.
Thank you. Bye-bye.
Thank you, Professor.